knows, and I don't wish to take you through authorities, but here is a small little line from a famous dictionary, Black's legal dictionary, which everybody knows about. A receiver is a fiduciary of the court, means he is a trustee of the court. He is a trustee of the court, he is a trustee of the parties, and he is also a trustee of the property or the fund entrusted to him. This property came into his hands as a trustee. But sir, he ceased to be a receiver when he became a judge. His receivership came to an end. But the trust which attached to the property which was in his hand did not come to an end until the trust became extinguished and the property got purged of the character of a trust property. If he realized that I have now ceased to be a receiver, it was his duty. If he had only cared to go through the report of these three judges, he would have realized that they knew as much law as we all know. They perhaps knew better. They did not rest content with finding this gentleman, I will call him respondent, I refuse to call him a learned judge as some people styled him. This respondent is not convicted because he misbehaved as a receiver. Of course, his misbehavior started when he was a receiver. The first misbehavior was that he has produced before you this whole document of an explanation of his conduct. Read this document. Not at one place does he say that I am a trustee, that I was a trustee of the funds which came into my possession. Sir, every child knows, and I don't wish to take you through authorities, but here is a small little line from a famous dictionary, Black's legal dictionary, which everybody knows about. A receiver is a fiduciary of the court, means he is a trustee of the court. He is a trustee of the court, he is a trustee of the parties, and he is also a trustee of the property or the fund entrusted to him. This property came into his hands as a trustee. But sir, he ceased to be a receiver when he became a judge. His receivership came to an end. But the trust which attached to the property which was in his hand did not come to an end until the trust became extinguished and the property got purged of the character of a trust property. If he realized that I have now ceased to be a receiver, it was his duty to walk up to the court and say that I am now becoming a judge. Please relieve me of this trust property which has been in my hand, and here is that property, take charge of it. Sir, he did not do this. He thought that when he has become a judge, all people surrounding him will turn into sycophants and will forget the 52 lakhs which he had pocketed. But unfortunately for him, there was a fellow judge in the High Court itself who did not become a sycophant, and he carried on an investigation into the trust property which was in his hands. Sir, look at this explanation, and at page 31 he propounds a doctrine, and I want you to hear this doctrine. It is judicially settled that till such time I as a receiver am not directed to return the sum lying with me, I cannot on my own return the same. In other words, he is telling you to accept the proposition that even though he ceased to be a receiver and it was his duty to go and give an account of the property which he received as a receiver to the court which appointed him as a receiver, he said, I am not bound to do anything of that kind until I am asked to do so. In other words, the trust property becomes personal property and I can deal with it as I like. Sir, this receiver lawyer should have known that as a trustee he is bound by the provisions of the Indian Trust Act. The Indian Trust Act has an express provision, section 20, which deals with investments. A trustee cannot invest trust property in 7 specified investments which are permitted under that section, and if you invest in any unauthorized deal, that itself renders you liable for a prosecution for criminal breach of trust. The law does not permit a trustee, because the law says in these 7 ones and no other. So clear is the law, and yet he went and invested this property according to him, whether he did it or no, but he went and invested it in a private financial business, which is not a government authorized entity in which he could have put this money, and he claims that that entity became insolvent, went into liquidation, and he thought that everybody will forget about that money. Sir, now for Mr. Mishra's bravery. If you had read this document, this report, and if you had come up to page 22, because I don't blame anybody for losing patience after you reach the 22nd page. At page 22, the report starts dealing with his misbehavior as a judge. All that is stated above took place, and I am reading the last paragraph on page 22. All that is stated above took place during the period when Sen, receiver, was an advocate. The assessment of the inquiry committee is that as advocate and as an officer of the High Court of Calcutta, Sen's conduct was wrongful and not expected of an advocate. But his conduct in relation to matters concerning the monies received during his receivership, after he was appointed a judge, was deplorable, in no way befitting a High Court judge. From here starts their dealing with his misbehavior as a judge of the High Court. And I regret to say that if there was a more vigilant method of appointment of judges, this man did not deserve to be appointed. But having been appointed, he has no business to stay as a judge for even one day. And this House will be committing a harakiri of its judicial functions if you don't rise to the occasion and see that not only this judge goes, but other judges who similarly misbehave do not occupy judicial offices for a day longer. Sir, there was a reference to his eloquence. Eloquence is doubtless a quality which people should possess. I must tell you that I've never heard Mr. Mohan Singh speak, but today I was so impressed while I was hearing your Hindi eloquence that I said, I hope before I die, I will one day be able to deliver a speech like you. But sir, eloquence has nothing to do with moral sense. Eloquence has nothing to do with a quickened conscience. Eloquence is often the property of the biggest cheats and charlatans. After all, unless you know this glib talking art, you will not be able to cheat people. And it is not a matter of surprise that today the glib talkers are at the top of the world and people who can't speak are not. Sir, this gentleman gave a demonstration of his eloquent deception. But why did he not appear before those 3 judges which were inquiring into his conduct? Because he is afraid of answering questions. I wanted to ask questions here while he stood there. In 3 questions I would have demolished his eloquence and he would have faltered, he would have fallen down here right in this house, would not have been able to go back. Because you can speak as much untruth as you like, so long as there is no risk of interrogation and cross-examination. That is why in a court of law, we do not believe a witness who has not submitted himself to cross-examination. Examination in chief is useless unless it has survived the filter of cross-examination, and cross-examination by people who know how to cross-examine. before every judicial authority where he could be questioned, he did not get up and answer. To those 3 judges who were holding an inquiry, they called him. He said, I am pleading the 5th Amendment. 5th Amendment is not meant for crooks like this. 5th Amendment is meant for illiterate accused who by answering questions might implicate themselves in offences which they have not committed. That of course is the origin of that rule. But now 5th Amendment is a constitutional right. But that right is available in a prosecution for a criminal offence. This judge was not being prosecuted for a criminal offence. He was being prosecuted for his ability and for his qualifications of being a judge and continuing to remain a judge of the High Court. He is not going to be sentenced to imprisonment. So, sir, don't be impressed by that kind of eloquence. He becomes eloquent wherever he can't be questioned. Sir, the next question is that he has paid 52 lakhs. He paid those 52 lakhs while that single judge caught hold of him and said, where is that money which you got as a receiver? You have not given it. So, sir, 52 lakhs he paid. And now some people, and I heard some of my fellow members in this house tell me outside that the man has paid 52 lakhs, why not let him go? But please understand, what did he get by paying those 52 lakhs at that late stage? What he got was, and he should thank his stars, he is an ungrateful man. He eats and gobbles up the hand which feeds him. Those brother judges who unfortunately continue to practice some kind of trade unionism to save their brother judges, they saved him from being prosecuted and punished for a serious offence of criminal breach of trust, punishable under section 409 of the Indian Penal Code, where the maximum punishment is life imprisonment, and imprisonment which may extend to 10 years. By paying off that money which he had pocketed, though of course I am sure his poor mother made some contribution to that money, he has earned his freedom from jail, and I assure you that if he had been prosecuted, he would have been in jail for at least 5 or 10 years. He has earned that freedom by that money, and please therefore do not entertain any sympathy for this man, that this man has paid 52 lakhs, let him go. This is not a settlement of a civil dispute. He was guilty of a non-compoundable offence under which you can pay millions and millions, but you cannot compound that offence. It is only an extenuating circumstance on the question of punishment. But that extenuation value he has already got out of that money, because he has escaped the whole prosecution under section 409, and the ignominy which he would have gone through, his family would have gone through as a result of a prosecution, and ultimately an appealing to the court to give him a lighter sentence because he has paid off. So my friends, this is a case in which you are dealing with a judge who ought not to have been made a judge if there were better methods of appointment, and who fortunately has been caught as a result of another vigilant judge. He talks at the division bench. If the single judge had no jurisdiction to go into the matters in which he went into, what was the division bench doing? The division bench merely said that you have paid this money, all right, you have paid this money, therefore, out of again that trade unionism and that little sense of mercy, that we will remove that remark that the single judge has made, we will expunge that remark. That judgment was a bad judgment, and that judgment is a judgment which was certainly considered by the Chief Justice, to whom a complaint went from the Chief Justice of the Calcutta High Court. Sir, that Chief Justice of India may be somewhat controversial, but so far as this judge is concerned, this Chief Justice helped him. He gave him an extra hearing. He gave him a hearing in his house. He listened to him, and then he said, I will give you an extra constitutional opportunity to establish his innocence, and gave him that in-house committee of judges who sat and listened to this man and said that you seem to be a hypocrite, you don't deserve any mercy, you face the consequences of the conduct in which you have indulged. So, sir, this is not a matter in which the House can take a lenient view. Let us settle a good precedent today, so that judges who are of the same mold of mind as this judge should realize that the parliament of this country will rise to the occasion and not do things which we have done in the past. Of course, sir, this is not an occasion to enter into a debate about the appointment of a National Judicial Commission. That's for some other time. But today I hope, sir, that even Mr. Mishra will withdraw his dissent and the decision shall be unanimous. And thank you.
Sri Ravi Shankar Prasad.
Sir, I am extremely grateful for giving me very short time, sir. I have to make very few points, sir. Justice Soumitra conduct as a judge, sir. He became a receiver in 80s, got sale proceeds in the early 90s. He became a judge in December 2003. The first thing was required to do was to submit to the court that I don't want to remain receiver any further. He did not do so. For whole 2005, for whole of 2004, he did not submit an account. And when the single judge issued him a show cause notice, he did not reply. Thrice notice was given. And most important, sir, it is very important, when a final order was passed asking him to pay 33 lakh with interest 55 lakh, thereafter he goes and pays for time. Part payment he make. A question has been asked about division bench, sir. I'll just take 1 minute, sir. That division bench relies upon his affidavit. But in the inquiry by your committee, it has been found that was a case of misrepresentation further. He said that I have invested in Links India. But that was not a fact. This received amount of the receiver, he did not invest there. Sir, it is a case of misconduct as a lawyer. It is a case of continued misconduct as a judge of misrepresentation. So therefore, I will request that this impeachment has to succeed. So only one point I have to make in the last. What is the authority of a judge? Is it the source of law? Is it the power of contempt or something more? Sir, we have seen additional district judges giving capital punishment, and yet after retirement they are moving in their mohalla, and all those mafiosis whom they have awarded punishment never dared to challenge them. We have rarely heard a district judge or retired additional district judge even been threatened or any revengeful action against them by those criminals who have been given conviction by them. Why so? It is the moral authority of a judge. This is a great tribute of our judiciary and our rule of law, that the moral authority of a judge is the most important authority. For that, integrity is very important. And if that integrity is found to be wavering, sir, it is time to take action. Sir, I will conclude with what the Honorable Leader of Opposition stated, that there is a need for a lot of improvement in judicial appointment. This whole appointment by collegium was a kind of constitutional appropriation by the judges from the executive, and the constitution not permissible. This needs to change, sir. It is very important. Sir, one thing more, sir, very important in the present context. Yes, judges' activism in probity in the fight against corruption is okay. But all over the country we are seeing judges are taking power by appointing committee. MCD should work like this committee should work like this. Sorry, my lords, it is not your function. Maybe the authority is not functioning properly, but for that you are not the authority. Let the democratic process, the rule of the law and the parliamentary accountability set right the course. That is important. With these kind words, sir, I fully support the motion which Mr. Yachuri has moved, sir.
Thank you. Shri Sitaram Yachuri to reply to the motion.
Thank you, Mr. Chairman, sir. You have any time limit for this, sir? As brief as possible.
Will that suffice?
Yes, sir. I rise in. Ji. Yes, sir.
Silence, please.
I am fully conscious of it.
Yes, please go ahead.
Mr. Chairman, sir, we are reaching the conclusion of a historic debate, and it's on the motions that I had moved, which is on the brink of creating history, not only in the history of our parliament, but I think in the history of our democracy. As I said at the outset, sir, I moved these motions not as an indictment or a reflection of our opinion of the judiciary as a whole, but I moved this motion in order to strengthen the independence of the judiciary, in order to establish the integrity of the judiciary, which was getting besmirched by the acts of one particular individual. And while moving this resolution, I had said we are doing this with no jubilation or elation, neither vindictiveness nor vendetta, but we are invoking legitimate constitutional provisions to ensure that the sanctity of our Constitution is maintained and the supremacy of the centrality of our Constitution, which is the sovereignty of the people, is established through their elected representatives, that is the Parliament. And in doing so, sir, I think we have today, in a sense, also reflected the general mood that is there in the country. We have seen these waves of protest against corruption at high places. We have seen the concern and the actual disgust that many in our country are reflecting in their own ways against this sort of corruption. And in the midst of that, the Parliament rising to the occasion and saying that we will invoke our Constitution, we will invoke the supremacy of the Parliament in order to ensure that corruption in high places will be checked, and when anything wrong is brought before us, we will act to correct it. That, I think, is a very important element today to convey to the country and our people the will and resolve of this august House in tackling corruption at high places. And this is something I think this debate has established, and that is why, sir, it is, I'm actually truly impressed with the richness of the debate, and it only strengthens my own confidence, further strengthens my own confidence that when the occasion demands, this august House has risen to the occasion, and has risen to the occasion in a splendid manner, and with no acrimony or no personal attributes. We have discussed an issue as serious as this, and on the merits of it, and it's a matter also that we had the leader of the House sitting through this entire debate, the Honorable Prime Minister. We had the Honorable Leader of the Opposition not only being present but contributing richly to the content of this debate, and which was shared by all, cutting across all political lines. And I think the richness of the debate also naturally transcended the limited purpose of the motions. It is only natural, sir. It naturally transcended the barriers of these motions in talking of the separation of powers between the legislature, the executive and the judiciary. It talks of the issues of separation of these powers, what should be the role of the judiciary, how the appointment should be done, and very natural that, and I'm very glad that these issues have been brought into public domain and in the discourse of the Parliament, so that in the coming days we should address them in all seriousness, and if time permits I'll return to that shortly, sir. But sir, there have been some questions that have been raised, and notably my distinguished friend and colleague, Mr. Satish Mishra, who of course told me and personally said that he apologized to me saying that I'm opposing your motion. So I said, what is a debate if there is no dissent? and like Ram had said, and I must thank Mr. Ram Jetmalani, and I must dare say, sir, I don't want to use this, but who else will come to the defense of Sitaram but Ram? In that sense, he's made my job much easier. He's made my job much easier by taking up some of these matters. But sir, an important question has also been raised by Mr. Mishra, and also by our distinguished colleague like Mr. Bharat Rawat, etc., on the question of the word and the concept of misbehavior. Now the question of what was his role of Mr. Soumitra Sen after he became judge, that Mr. Jetmalani has answered, I don't want to repeat it. And on many of the other issues, Mr. Ravi Prasad has answered some of the other issues. I don't want to repeat, only for the sake of time, and also respecting the reminding that Mr. Ahluwalia has said about the iftar and the timing of it. I don't want to go into all those aspects of it. But the word misbehavior, sir, this inquiry committee that you had established, actually goes into the genealogy of this particular word, which to paucity of time I didn't read out at the time of introducing the motions, but I'll read out now. It's a short passage which says, I quote, "The word misbehavior in the context of judges of the high courts in India was first introduced in Proviso B to Section 202 of the Government of India Act 1935. Under the 1935 Act, it was initially the Privy Council and later the Federal Court of India that had to report to India's Governor General when charges were made of misbehavior against a judge of a high court. In the report of the Federal Court in respect of charges made against Justice S.P. Sinha, a judge of the High Court of the Judicature of Allahabad, one of the charges made by the Governor General against the judge were, quote, that Mr. Justice S.P. Sinha has been guilty of conduct outside the court, which is unworthy of and unbecoming of the holder of such a high office, unquote, which was then particularized. Since this charge was not substantiated against the judge by evidence, it was held to have been not established. But the charge, as there framed, has tersely but correctly described the scope and ambit of the word misbehavior, namely, guilty of such conduct, whether inside or outside the court, that is, quote, unworthy and unbecoming of the holder of such a high office, unquote. The same word misbehavior now occurs in the Constitution of India in Article 1244. When read in context of Proviso B to Article 2171, these provisions state that a judge of the High Court shall not be removed from his office except on the grounds of proved misbehavior. The prefix proved, which my friend had quoted, only means proved to the satisfaction of the requisite majority of the appropriate House of the Parliament, if so recommended by the Inquiry Committee. The words proved misbehavior in Article 124 have not been defined, advisedly so, because the phrase proved misbehavior means such behavior which, when proved, is not befitting of a judge of the High Court, unquote. And the entire discussion we have had in the last 2 days here has only proved that there is a misbehavior on the part of Mr. Soumitra Sen, and since this has now been proved, in my opinion and contention, which we will decide upon through a vote subsequently, that this has been proved according to in a House of Parliament on the basis of this discussion that we have had, after giving all the time required, in fact extended time required for Mr. Soumitra Sen to make his defense. If after that we come to that conclusion, sir, that is the meaning of proved misbehavior. And that proving we have to do. And are we convinced about that proving? That is what we have to stand up to, and that is what we have to do, sir. And that is what is that issue that was there. But with regard to the other thing of which Mr. Jethmalani answered it, about the role of Mr. Soumitra Sen after he became a judge, and in fact, he just quoted the introductory paragraph, but if you just go through the Inquiry Committee report, sir, there are at least 4 major sections and at least seven subsections where the Inquiry Committee has established, after becoming a judge, the misbehavior of Mr. Soumitra Sen. And this is all there on record from pages 22 to 25, 26, and I do not want to take time reading them out, and it's all there on record and as part of the evidence that we have. So it is not a question of today we passing judgment or discussing about Mr. Soumitra Sen as an advocate and not as a judge. And also, as I said when I was moving the motion, it is no longer tenable to say that these charges were made against Mr. Soumitra Sen before he became a judge. Therefore, the Judges Inquiry Act does not apply to him, since it was not when he was a judge. And that has also been established under law, that it is not a question, and what I have established on the issue of misbehavior that I have just quoted to you, it is not a question of when you are a judge or when you are not. It's not a question of whether you're doing it in the court or you're doing it outside, but the question is whether your behavior will cast aspersions not only on your character integrity, but the character integrity of the entire judiciary, and therefore you are liable. You are liable to be drawn under this section. So that is why, sir, Mr. Bharat Raut has also raised the issue of the division bench. Mr. Ravi Prasad has referred to it, but let me just take up this matter on behalf of what the inquiry committee said, sir. He said, as the division bench, it's been so, and Mr. Jetmalani also answered that. Mr. Arun Jaitley, of course, answered it in the morning. And when he also exposed, I'm not repeating that deliberately, when he also exposed a lot of false and misleading statements that Mr. Soumitra Sen made here, and with authenticated documents, which I would want him to authenticate and place before the House and make them the property of the House, because, sir, I will come to that why I am saying it subsequently before I conclude this presentation, but I would only request the Leader of the Opposition to do so. Sir, on the division bench, this is what the inquiry report says. The observation, I quote, the observation in the judgment dated 25th September 2007 of the division bench of the Calcutta High Court to the effect that there was no misappropriation of receiver funds by Justice Soumitra Sen was, after considering the uncontested affidavit filed on behalf by his mother, which categorically asserted that the entire sum received by him from the sale of goods, that is 33,22,800, was invested in Links India Limited, and that the company had gone into liquidation a couple of years later. This statement, along with the further misleading and false statements in ground 13 of the memorandum of appeal that they have appended to this report, were material misrepresentations made by and on behalf of Justice Soumitra Sen before the division bench of the High Court of Calcutta. The finding by the division bench in its judgment of 25/7/2007 that Soumitra Sen was not guilty of any misappropriation was made on a totally erroneous premise induced by the false representation made on behalf of Justice Soumitra Sen, unquote. I don't think you require greater clarity than this. I don't think there's greater clarity than this, and therefore what was the misbehavior or what was the misappropriation that was done? Indian Penal Code 409, and I must, Mr. Jetmalani of course pointed out, what was the deal? You know, why did he pay back the money when he was asked to pay back? And to escape imprisonment. But then, sir, Indian Penal Code 403, the questions were raised on the question of misappropriation. Is diversion a misappropriation? Is using that money temporarily for some purpose a misappropriation? And we heard the neighbors of Mr. Soumitra Sen yesterday when he said, you tell me 1 paisa that is there in my account. Have I made any money at all from all the holding these monies? So therefore, there is no misappropriation that I have committed. But what is the definition of misappropriation in the Indian Penal Code, sir? I quote, 403 Indian Penal Code. Whoever dishonestly misappropriates or, please underline, converts to his own use any movable property, etc., shall be punished with imprisonment. Then it goes on, converts to his own use. Then it goes on to also clarify in the explanation, a dishonest misappropriation for a time only is a misappropriation with meaning of this section, within the meaning of this section. So whether it is for a short time, whether it is for personal use only to be returned, even if you are a fiduciary and a trustee, if money is deposited with me, I cannot borrow from that money even temporarily for my personal use and return back that money. I may be very honest and return back that money, but the very act of borrowing from that money makes me guilty of misappropriation. That is the Indian law, sir. And that is why our law is very clear. It is both acts of omission and commission. You cannot say that I don't have any money that I have put in my bank accounts and therefore I am not guilty. But your acts of omission that have led to such acts of guilt are actually breach of law. So therefore, on all these counts, sir, that whatever all the matters that we have discussed earlier, that 1984 he is appointed a receiver. The matter is finally settled in 2006. In 2002, SAIL asked for the accounts of what happened to those monies. 2003, he doesn't reply immediately. 2003, yesterday he was telling us in a very labored manner. The whole 2 hours of it, there was only one mention of sales. And that mention came in the term of the reference to the learned counsel of the Steel Authority of India. When the whole case of misappropriation centers around the money of the dispute between the Steel Authority of India and the Shipping Corporation of India, and he was made the trustee of it. For that there is no reference, but he's of course asked me to go back to my workers and find out if they have been paid. I'm grateful. I mean, if that has happened, I mean, sometimes justice can be done by these courts also, and by such judges also, if the workers have been paid. But that is not the issue. Who gave you the right of the 70 lakhs of rupees that was given to you to pay to the workers, to divest 25 lakhs of that and invest in a company, a private company, which was going into liquidation? Is there a scam involved in that? That should be investigated, sir. That you have divested 25 lakhs of money that was set aside for wages and compensation of the workers to be invested in a private company which goes bust within a couple of years? Was it done with knowledge that it is it is going into liquidation? What is the feedback there? That also needs to be investigated today, sir. So these are various issues that have been coming up, which have all come onto the record now. How fictitious accounts have been recorded, how checks have been issued for the payment of credit cards. Abhi hai na? 6:40 hai na?
We need time to vote also.
Yes, sir. And therefore, sir, keeping this in mind, as I mentioned again, the case according to me is a closed case.
Thank you.
And finally, the point that I want to make, the labor of the entire argument yesterday was there is a great conspiracy against. The conspiracy is what, sir? You have the Chief Justice of India. You have noted judges like Justice A.P. Shah, A.K. Patnaik and R.M. Lodha. They have all conspired against Mr. Soumitra Sen. You have the Chief Justice B.N. Agarwal and Ashok Ban, the senior most judges. They have conspired against Mr. Soumitra Sen. And now, Justice Sudarshan Reddy, Mukul Mudgal and Farid Nariman. All of us know him, and we had the pleasure of serving. I mean, he's been our colleague here. And we've known him operate here. And to trust the integrity of such people, and to say all of them have colluded in a great conspiracy to persecute Mr. Soumitra Sen, is a great conspiracy theory that has been woven yesterday, and that conspiracy theory needs to be busted. So therefore, sir, finally, I think the issues that have been raised by the leader of the opposition, echoed by many others here, on the larger issues connected with the judiciary, executive, and the legislature, this debate today and this motion today after we adopt should be used as the trigger for us to continue with these discussions, so that we, as a party, the CPM had always been asking and continues to ask even now, along with this Lokpal, for the establishment of the National Judicial Commission. We think that should go together. And these are issues that we have to finally take up, because our constitutional scheme of things talks of judicial review, not judicial activism. And that is why, sir, the judges, honorable judges, will interpret the law, but unfortunately, the power to make law lies with the Parliament, and that is the supremacy. And it is that supremacy that we should uphold. So finally, sir, let me go. Finally, let me quote Nehru to you. Sir, during the Constituent Assembly debates, he says, no Supreme Court and no judiciary can stand in judgment over the sovereign will of the Parliament. Over the sovereign will of the Parliament, representing the will of the entire community. If we go wrong here and there, the judiciary can point it out, but in the ultimate analysis, where the future of the community is concerned, no judiciary can come in the way. Ultimately, the fact remains that the legislature must be supreme and must not be interfered with the court of law in measures of social reform. So, unquote. So this is something that we will have to uphold, and therefore, sir, I thank all those who participated in this debate.
Thank you.
And through you, urge that the motions that I have moved yesterday be accepted, and I therefore recommend once again that these motions be accepted by the House. Thank you, sir.
Thank you. I shall now put the motion moved by Shri Sitaram Yechuri for presenting an address to the President for removal of Justice Soumitra Sen, Judge, High Court of Calcutta, from his office, along with the address to the President under Clause 4 of Article 124 of the Constitution to the vote of the House. As I have informed earlier, the motion along with the address are required to be adopted by a special majority. The question is, this House resolves that an address be presented to the President for removal from office of Justice Soumitra Sen of the Calcutta High Court on the following two grounds of misconduct. 1. Misappropriation of large sums of money which he received in his capacity as receiver appointed by the High Court of Calcutta. And 2. Misrepresented facts with regard